as early as practical. So the 7/10/30 notice was given on May 3rd, 2019. So there's a notice of the possibility that they're going to have this prior identification.
Right.
So there's adequate notice back in May of 2019.
So it is a little bit different in that Purdue was a first time, right? There was no, and this isn't the first time. This is the third or fourth, depending on if you include the lineup, third or fourth bite of the apple.
You've already made that point. We understand it.
And it was also a little different, Justice Montour, in that this was basically a show up. It wasn't just, yeah, that's him sitting there. This was come over here and show your teeth. I know that's not testimony. There's court case law that's not testimonial necessarily, but it's a little different from Purdue in that way as well.
We'll look at that very carefully.
Thank you, Your
We
Honor.
have that argument. Do you have something further?
I would just add that there was enormous prejudice and an enormous risk of misidentification, given the situation, and balancing the probative value of that identification against those dangers deprived Mr. Howard of a fair trial. Unless there are questions on the other points, I would just ask the court under point 4 to modify the order of protection, as the people do concede that the math was wrong. And it's just really fun to say that people concede.
Thank you.
Good morning, Your Honor, Sarah Schwally for the people.
And I assume you do concede that.
I do. I haven't changed my mind. Initially, just briefly with respect to point 1, the in-court identification, I would submit that the issues raised on appeal are not preserved because the objection at trial was general. And on the merits, I would just submit that this case falls squarely and neatly within the parameters set by the Court of Appeals and People v. Purdue for the reliability of a first time in court identification. And if Your Honors don't have any further questions, I'll rest.
Thank you.
Thank you.
946 in the matter of Anna Vias B. And we're going to have 946, 951, and 956 all together. I think. Morning.
Good morning,
I'm
May.
going to call all 3 at once, okay?
Yes, thank you. I was hoping you would do that, Your Honor. So it appears that neither of my colleagues are arguing today, so they must be relying on their briefs, of course. I would generally rely on my brief, but just briefs, just to point out, these children need some permanency. They have been through an awful lot in their life. They've been in care. It's a family placement, but over 5 years. I did a quick search this morning just to see where the appellant's criminal appeal is, and it still has not been perfected. Looks like he has until January 21st to perfect the appeal. My client's lives are marching on, and the appellant has limited his brief to the ineffective assistance of counsel argument, which I don't believe has merit given what his options were. He either could go to trial or surrender, and he elected to go to trial, and the case.
Yeah, he was even advised, I believe, to.
Right.
And let's try to figure this out, right?
Right. So we would ask the court on behalf of the children to affirm the lower court's decision so they can move one step closer to permanency. Despite everything they've been through, they're pretty engaging children. They seem to have good heads on their shoulders, but they do have a lot of issues, and the holidays are extremely difficult for them. And we would just ask the court to affirm the decision. Unless there's any further questions, I'd rely on my brief.
Thank you so much.
Thank you.
947, Michelle King versus Michael King Jr. One moment, please. We just have to wait for, oh, there. Good morning. Okay, go ahead.
Good morning, Jonathan Garvin for the father, Michael King. May it please the court.
The referee's determination to grant sole custody to the mother lacked a substantial basis on the record. Therefore, it is entitled to no deference. And we ask this court to substitute its own discretion for that of the family courts, which it's entitled to do, even in the absence of abuse of discretion. I just would like to, because we have to operate under the totality of the circumstances, I'm just going to briefly highlight some aspects of the record that were overlooked by the court, as well as the opposing parties' arguments. I'm going to address the third-party provider issue first. There's no basis in the record to find that Mr. King had anything to do with. I'm talking about the pediatrician. The court said that the pediatrician will not interact with the father. There was no evidence of that.
I will look at the record.
And there's no evidence that he did anything to prevent the child from.
Are you referring to the court coordinator?
No, I'm referring to I'm referring to the minutes after the referee's decision, his comments. I'll get to the coordinator later, unless you want me to address it now.
Go ahead.
Okay, so and in fact, the mother admitted on cross-examination that the letter that she was relying on to say that the pediatrician had dropped the child from services didn't actually say that. And so there's no evidence. So there's really no reason for Mr. King.
Okay, we'll look at
to
that
have-
very carefully.
Okay.
On to your next point.
And also there was a temporary court order authorizing the pediatrician that supposedly didn't exist to do eye and ear exams. As for the dentist, relying on Stone v. Weinberg, I say this was just a disagreement about where the child should have dental services.
But he didn't come up with an alternative dentist.
He did try to come up with an alternative dentist.
It would have been out of network though, right?
Out of-
No,
It seemed as though he was more interested in choosing someone that was out of network that would have cost more, not trusting of the in-network dentists and that situation. It seemed to be.
I understand that's the mother's position, but that is not borne out by the record. And two things. Mr. King testified both before trial and at trial that there was an agreement on a dentist in 2021. And that the mother didn't follow through. And he urged the referee to look at the minutes as the referee said he was going to do that would prove that. And the mother never said that there was, in this time period, first the mother said we couldn't agree on a dentist. Then she contradicted herself and says, well, he does have a dentist. And then the question was, oh, she has a dentist now. Well, when didn't she have a dentist? And it was only evidence is that there wasn't a dentist before July 12th, 2021. And that's beyond that. But father, this answer the question, the father did testify that that the dentist that he selected was in network, although the coverage was not, the mother's coverage was better.
Okay, we understand the dentist issue. Can you go on?
Okay.
I think all in all, though, that sort of demonstrates an inability of the parents to cooperate in the best interest of the child. Wouldn't you agree?
No, I wouldn't agree because I would agree that there was acrimony in the relationship, but I don't think it rises to the level of to strip Mr. King of all decision-making authority. And the case I cited on page 22, the appellate division upheld a joint custody relationship, finding that there was a modicum of cooperation and communication based on that they were able to keep a custody schedule for 8 months and accommodate phone requests. And I think we have much more here where
I think we understand where you're going with this, but why don't you go on to the problems with the teachers and at school?
Okay. First of all, there wasn't any educational neglect alleged in the mother's petition. When the mother was going through the the change of circumstances in the beginning of her testimony. In terms of the academics, she said that there was the problem with academic services. And
Let's talk about having to be escorted out by security at the school, but never looking at the dad folder. That nobody, it doesn't sound like anybody at the school really trusted him. The father stated the school never invited him to parent-teacher conferences, even though the principal himself sent emails to him regarding that. How do you explain all that?
just to finish my sentence, there was no.
I'm sorry, not by emails, by
Okay.
certified mail.
The certified mail was, first of all, the court noted that it was, and the reason why the record is interesting is all the court looked at, and this is the court's own decision, because there's all these allegations of all these things that happened that the court did not consider, and that's a failure to exercise its discretion. The court said, because Mr. King admitted to friction between the school district, that was all he was considering. He said, I'm not really looking at the other parts of the educational allegations. So he said, I'm not looking at the whether, you know, you're talking about being escorted out. That was something that Mr. King was very traumatic to the child to see that happen to the child, and that was done in front of the child. And he wasn't considering the two instances that he testified that were not shown to be. We don't know, because there's no testimony from the school. We don't really know the circumstances or the context of what's going on.
Okay, we'll
But we
look at
do-
that very carefully. Do you have anything further? Because your time's almost up.
Do I have
Do you have
10
anything
minutes?
further? Because you had requested 10 minutes, I believe, so could you wrap up?
Okay, well, I want to just briefly talk about counseling that Your Honor brought up. The argument is that Mr. King from October to March delayed counseling, and the record does not support that. First of all, the initial petition was a violation petition that had nothing to do with counseling. So, and the court didn't rule made no ruling on that petition, and that's not before the court. And there's no arguments about picking up and dropping off and the other allegations. So.
Counsel, before your time is up, I want to give you a chance to address this. I thought the court found that the mother had a better demeanor and temperament to be the sole custodian of the child, based upon the numerous CPS calls, the numerous police calls, and as our justice presiding testified or has talked about the being barred from the school, you know, based upon the totality of all the evidence. The lower court thought the mother had a better temperament.
Well, there was no evidence to support that. The court did say that. Your Honor is correct, but you know, Mr. King disputed that, and he wasn't allowed to really address that because the court, one, because he admitted that there was some friction, that was the end of the story. Two, wouldn't hear from the child, wouldn't hear from the principal and the teacher, which deprived him of, you know, to address that. There's not a factual, there's no context, and there's no, we don't really know why. And we just know that there is an issue. There was an issue with the school, but it wasn't necessarily, just because there was friction, it doesn't mean it was solely based on anything that Mr. King did. We just don't know. So.
Well, we do know they put him out of the school though, right? Or did they?
They did.
Did
When
they
he was-
escort him out or not?
There was a time when he went to pick up his, it depends what you mean by a score. He went to pick up his daughter, and the security thought he wasn't entitled to pick her up that day, that the child was sick. They confronted him, and Mr. King was worried about how this confrontation would affect the
He
child.
was escorted out.
he was proven to be correct that the nurse came in and said he is allowed to take the child that day. So the security was incorrect that he was doing something wrong. He was allowed to pick up his child. They confronted him and he took his child home. If you want to say, I don't know if they really escorted him, but they were concerned that it wasn't the father's day to pick a child up, but they were wrong. So
Okay, I think we
that's it.
have that. Can you wrap up, please?
I just want to briefly address point 2 and why it was improper to cancel the parental coordinator. The parental coordinator was not only supposed to mediate disputes. If she was unable to resolve disputes, the mediator was supposed to write decisions, and the court was supposed to exercise oversight over the implementation of the court-ordered parental plan. The parental coordinator did not do her job, and the referee did not do any oversight. The mother admitted that she did not have an opportunity. The court itself asked the mother, why didn't you bring up your issues with dropping off and picking up with the mediator? And she said, I didn't get an opportunity to do so. We only met for 45 minutes. And we maintain that that's insufficient to do all the processes that the court laid out in its 2021 order.
Okay, we'll look at that very carefully. Thank you.
And okay, so we just in conclusion, we're just asking some of these disputes could have been resolved by, in terms of judicial efficiency, if that process had gone through.
Okay, I think we understand that, and your time is way over, so thank you.
If there are no further questions, I will rely on my brief. Thank you, Your Honors.
May it please the court, Nathan Van Loon for respondent Michelle King. Fundamentally, it's a stability versus chaos argument that I think that referee Polito judged, and he judged based upon the facts that were in front of him, and he made a determination. It wasn't a determination my client completely agreed with, but it was the determination was made, and it was based on facts. You've got crisis over doctors, dentists, school. You've got somebody who won't even look in the school bag. That's how much they don't want to be involved in the school and activities there. You're having disputes over something as simple as whether somebody should be an in-network therapist or in-network dentist, as opposed to out-of-network dentist and out-of-network therapist. So you have that fundamental chaos that exists, which rises to the Brayman standard, which is what referee Polito pointed out in making his determination and granting my client sole custody. I think that was appropriate. As far as the parental coordinator, it's pretty clear from the record that yes, there was one 45-minute session, but clearly that session did not go well. And I don't know if the court felt that referring the matter back to a different parental coordinator was appropriate or not, but the court made the decision to make it have a hearing and follow through on the facts that were in front of them. That's my position, and if there are any questions, I'd be happy to take them.
Thank you.
Thank you.
Spending.
Yes, thank you, Your Honor. Mary Hope Benedict for the child. Just briefly, because most of the arguments have been laid out, but it's our position that the family court was correct in awarding the mother sole custody. This is an extraordinarily hostile relationship between these parents, multiple police contacts for the child. The dad doesn't look in the school folder. These things are detrimental to our client. So allowing the mother to be in charge of the school decisions, the medical decisions, the counseling, the dentist, this is all to the benefit of our client. And I would ask the court to find that the referee's decision is based on a substantial evidence in the record. And just to I know you know this, but this referee has had these people for years. He did 2 trials in 2 years. And just to update the court, These parties are again in family court. Petitions were filed almost immediately after this decision. They are having the second day of a trial on the mother's modification petition. She is seeking full placement and supervised visits to the dad, and the dad has 2 violation petitions. The first day of the hearing was in August, and I'm unclear why it was delayed so long, but the second day is not until January. But just so the court is aware of the current status of the
How is the child?
situation. I'm sorry, Judge.
How is the child?
The child is stressed, Your Honor. The social worker in Rochester and the trial AFC have met with her 2 or 3 times since this decision has been made. And this is clearly a situation where there's a little 8-year-old who is being pulled in 2 directions to her detriment. And there are concerns about her well-being. So I don't want to. I don't have permission from the child to reveal anything that she stated. However, Judge Mazza has indicated that she will have a Lincoln hearing, and I think that will be very beneficial.
Thank you.
Okay, thank you, Your Honor. If there's any other questions, if there's no questions, I just rely on my brief.
Thank you. 9:48. On the matter of Grace Pachelski versus Timothy Lemke. Sorry, just a minute, we gotta wait for everybody. Great, now. Great, thank you. Go ahead.
If it pleases the court, Rebecca Cons on behalf of the appellant mother. We'd like to state that it was not in the best interest of the child for the father to have sole legal custody and primary placement of this child. The mother has concerns over the father interfering with her relationship with the child. He's been missing visits and interfering with phone calls. He's gone as far as requesting that the mother not email the child. There's also concerns about the medical care that the child receives while in the father's care. The father has testified that he doesn't believe in yearly physicals. He has the child in total control of his medication. There's even been some events where the child has had an allergic reaction. He's allergic to peanuts.
Yes, because this child is now 17, about ready to turn 18. Am I correct?
He is. Yep, he's 17 at this point. So we're asking for a reversal. At the bare minimum, a set visitation schedule should be placed. This child shouldn't have been put in a position to have to choose between the 2 parents. His wishes should have been considered, but they shouldn't have been determinative. And if the court doesn't have any further questions, I'll rest on my brief.
Thank you. Go ahead. Mr. Gannett, can you unmute yourself and go ahead? You need to unmute yourself. You're still muted, sir. I'm sorry, we can't hear you. You need to get yourself unmuted. Can tech help with this at all or not? Hmm?
It's on his end. Yeah.
Your Honor, I've asked him to unmute. He should have the question up on his screen.
Is it possible to explain to him how to do that?
Should just have to hit yes on the question.
Okay, we've got an issue here. So there's nothing we can do from our end, am I correct?
Your Honor, it should be in the lower left corner.
There we go.
All right.
You're unmuted. Thank you. Go ahead.
Okay, Robert Ganand for the respondent. We've submitted our papers and I would just like to make a couple comments. The respondent father and the attorney for the child both agreed that the trial court did not abuse its discretion in determining that the respondent father have sole custody. The court's decision had a sound and substantial basis on the record and was in the child's best interest. I would note that Luke is obviously intelligent, knows what he wants, and at this time has control over his choices. In a little
Again,
more
he's
than,
almost 18 years old, correct?
right, in a little more than 3 months, he will be legally an adult. I submit that he obtained that status some time ago, albeit not in legal terms. It's our position that the court affirm the lower court decision. And if there are no other questions, I rely on my brief.
Thank you. Go ahead.
Good morning, Peter DiGiorgio, attorney for, I won't say child, I'll say attorney for almost adult. As Justice Smith has pointed out, he will be 18 in March. And assuming this decision comes out sometime in January, the parties will be living by an order that would be about 6 weeks old before this young man becomes an adult. I've set forth everything in the brief. Luke is an intelligent young man. He likes the ability to decide the contact with his mother. And I will note, there's one thing I do want to bring up that I think was indicative of this whole case, is that here we had the 17-year-old boy go to DMV with his driver's license, and his mother made him voluntarily surrender that because it was lacking a middle initial, which corresponded with her name that was added to his legal name, her maiden name or something like that. And that was devastating to him. I wasn't the trial attorney, but I can imagine a 17-year-old going to the DMV and not having his license. It's probably one of the more important things when I was 17 years old. But sound and substantial basis in the record for what the court did. And whatever this court does is going to be in effect for merely 6 or 8 weeks. Luke is doing well, and we ask to affirm. Thank you.
Thank you. And don't go anywhere, Mr. DiGiorgio, okay?
Are you going to lose me, or do I stay right on the screen?
I think you can stay.
Okay.
Okay, 949, Sevilla versus Torres. Oh, you can go, sir. Thank you. Go ahead.
Am I only I'm the only player here?
Yep,
You're
solo.
Attorney for another young man, Gio. I'm going to pretty much rely on my brief. You may be asking, how did I advocate here? The trial lawyer apparently was.
That's a question I have, Mr.
That's
DiGiorgio. The trial AFC advocated for extraordinary circumstances. The trial AFC was there present during all the hearings. The trial AFC was able to witness the demeanor of the witnesses, witness the contentiousness of the parents here. And as you know, that trial AFC advocated for extraordinary circumstances.
Yeah,
and,
absolutely.
And in your brief, you're arguing contrary to that.
Absolutely. I met with Gio.
So you don't think there was any domestic violence? Is that what you're saying?
It's not for me to make that call, Your Honor, with all due respect. Gio had a very substantial position as a 17-year-old when I met with him, that he wanted to go live with his mother. And I'm obligated by the statute, by the rules, to advocate the position of the child. It's not for me to determine what's best for him. I didn't.
That's what the court found. The court found extraordinary circumstances based upon the domestic violence, right?
Correct. And even though the trial AFC, either using substituted judgment, which I doubt that trial AFC did, perhaps Gio had a different position at the trial, argued for extraordinary circumstances. When I met with Gio, and I was very clear with him, He is no longer wanted to stay with his grandmother. He wanted to be with his mother, albeit he hasn't seen his mother in a bit. I don't know if his mother is still in that relationship right now. Again, I wasn't the trial lawyer for this, but he was very clear he did not want to remain with his grandmother. He wanted to live with his mother. And I advocated pursuant to the rules of the Fourth Department and the Court of Appeals in advocating his position. It makes being the life of an AFC very difficult when kids change their minds. I've had kids change their minds in the middle of trials, but I'm fulfilling my obligation as AFC.
Thank you.
There's no further questions. I'll rely on my brief.
Thank you. 9:50 in the matter of Sophia M. Okay, go ahead.
Thank you, Your Honor. I'm Charles Greenberg, representing Shannon G., who was adjudicated as having abused Sophia M. There's no question that that the baby was injured. I mean, she was presented at Children's Hospital with broken ribs and a false.
We know about that.
Yeah, so we're not going to pretend that everything is fine because obviously somebody did it. But I think it would have been a reasonable conclusion to state that that Casey, the child's father, who apparently dropped Sophia. And the reason why I say that, because this case can be distinguished from Grayson RV and Tyree B, because in this case, Shannon immediately sought medical attention for the baby. The baby wasn't just, suffering for several months before somebody did something about it. She immediately went in and took the child to Oshai or Oshai Children's Hospital. And that I think is the key that the abuse adjudication should be vacated.
But she took the child immediately for the fractured skull, but the rib fracture had been in existence for a period of time, it wasn't?
I think they were both discovered at the time that they took her in.
It was discovered then, but didn't the doctor say it didn't occur then? It had to occur at a different time?
I don't think so, Your Honor. I mean, that could be, but when it became clear that the baby was suffering, Shannon took immediate action.
Well, that's sort of admirable, I'd say, but I don't know if that's the strongest point.
Well, I also think, another strong point is the fact that when Casey testified, he did not address the issue of whether the baby was abused, but she instead was apparently brought forth solely to discredit Shannon. So therefore, you have the negative inference that you could also point to.
Thank you.
Thank you. Any other questions?
Go ahead.
Please the court, Russell Fox for the child Sophia, Legal Aid Bureau of Buffalo. You hear the mother's explanation, the appellate's explanation was inconsistent with the severity and nature of these injuries, and that's the key point. There was unrebutted medical testimony. Just to address Justice Ogden's point, the thing about the rib injury here was that the unrebutted medical testimony was that it would take an extremely high degree of force and trauma, equivalent to a car accident or a drop from a multi-story building, to cause that rib injury. The mother's testimony did not address how that could have occurred, did not sufficiently explain it, and the judge, which had the opportunity to view the appellant's demeanor and assess that testimony, and there were credibility issues with that testimony in terms of whether she had struck the father. It's collateral, but it still goes to credibility. I submit that the judge's determination did have a sound and substantial basis in the record. My 2.5-year-old client is doing well now in the care of the paternal grandmother. We're pending further proceedings in the case with regard to her permanency. Thank you.
Thank you. 9:52, Tina Calvinicio versus Jean Calvinicio. Did I say that correctly or not even close? Calvinicio. Okay.
May it please the court, Your Honors, Kelly Farron for the appellant Tina, now known as Nunez. As this court has held in the past, the custody determination must focus on the best interests of the child, the continuing of the stability of the household, and the existing custodial arrangement. The lower court here abused his discretion by not doing so. The appellant in this case has been the continuing stable force in Giovanni's life. There were no countervailing circumstances to warrant any change in custody. The appellant is fit and proper and has been the fit and proper parent for Giovanni up until the lower court changed the legal custody of Giovanni. And I say that because the court did nothing with respect to the access between the parents. A respondent, the father here, cannot rely on creating hostilities through his unwillingness to participate and communicate as a means to gain custody. He can't, fail what he did, fail to respond to communications, unwilling to transport the child, telling her, don't schedule things on my time. He basically frustrated communication. She'd pass along information, he wouldn't respond. Pass along information, he'd ask again and again. She responded until the point of her frustration. Withholding of parental access during the COVID pandemic is not a violation. And the third department has found that in the matter of Joseph X versus Raji YY. The mother here had legitimate concerns to withhold access immediately upon March 2020, when everybody learned of this COVID pandemic. Giovanni suffers from asthma. So that was her legitimate basis. She offered virtual access. She offered telephone conferences. He declined. Dad declined.
We understand all that.
Okay, thank you.
Mr. Barron, what about Dr. Nathanson's report concerning the mother's influence and constant disparagement of the father was having a negative impact on the child's perception of the father?
I don't believe Dr. Nathanson specifically says that. He says that the dad exaggerates. He said that the dad exaggerated with respect to his access, with respect to the COVID virus and the access he had. He said the dad is prone to distortions. He also says that the respondent does not accept Giovanni for who he is. And I think that's very important.
One thing I think we should stop doing is referring to the child by name.
I'm sorry.
Should be referring to the child or just, a G or something like that.
Okay.
Want to identify the child.
Thank you, Your Honor.
Thank you, Mr. Barron. Appreciate that.
So the respondent does not accept the child for who he is. We had testimony from Ann Roseberry, who was the child's counselor. She said that it's hard for the child to be at respondent's home. She said that the respondent makes the child feel anxious. And why? Because it's habit. Why? Because the child has to change his clothes. The child is very exuberant and expressive in his clothing. He had to put on like basic brown and
We
black
understand all that.
athletic clothing. And that's so he doesn't accept the child for who he is. That makes the child uncomfortable in dad's home. The dad makes hurtful comments regarding the child. That poses to the child some stress, anxiety, and to basically just a lack of support for who he is.
Okay, I think we understand that.
Okay. Of importance is that the father did not know who the child's teachers were, did not recognize the child's needs. He did not have the ability, I could strike that. He did have the ability, and Dr. Nason does point this out, that he had the ability to be involved in the child's education and healthcare providers, but he basically chose not to do so. He explained that the dad was unprepared for the authority as a custodial parent, as his decisions, such as trying to pull him out of counseling and switching schools, was not aligned with his best interests.
Right, we'll look at all that very carefully.
Okay.
Can I ask one quick question?
Sure.
Unless I'm confusing this with something else, didn't the mother's access kind of basically remain the same?
I would say the father's access remained the same. There was no change of access between mom's house and dad's house.
Okay.
The lower court did grant dad some makeup time, I think it was referred to, because of the COVID pandemic and the situation that occurred with COVID. But the access plan between mom's house and dad's house did not change.
Okay.
All that changed was the so-called custody, which I'm referring to and posing to this court as the legal custody, dad making decisions for the child.
Counselor, what is the change in circumstance? The relationship was acrimonious all along. What is what is alleged to be the change in circumstance?
Dad's alleging the change of circumstance is his communication with the mom. Mom was alleging that the acrimony between the two of them got to a point where it had to be addressed. But mom had sole custody from the beginning when they got divorced. She also had an order of protection because of some domestic violence. And I would submit that, domestic violence doesn't end upon parties getting divorced, but that interaction between the parents continued, and it's continued in this case. But I don't believe there really was a change of circumstance. I don't see it and I don't think that the trial court really saw it because there was no change in access. The issue here that the parties were looking at and were presenting to the court were that, access should be changed. Giovanni, sorry.
I know.
The child was uncomfortable, from mom's understanding, uncomfortable in dad's house, and mom tried to have the court address
I think we
that.
have your
Yeah.
argument.
With respect to my second point, justices, is that the attorney for the child erred in substituting his judgment for the child's wishes. He did not advocate for the child's position. At the time of the hearing, the child was 10 years old. He had the capacity for making a knowing, voluntary, and considered judgment. He was not likely to, his position was not.
Wasn't his position, however, that the mother was basically coaching the child and that was problematic in coming to a decision of how to advocate for the child?
That's what he said to the court, but there's no proof in the record of that.
Okay, we'll look at that.
Yeah, Dr. Nathanson didn't find that. Ann Roseberry did not find that.
We'll look at that very carefully.
Thank
Do
you
have
very
anything
much.
further?
So with respect to this, Your Honor, I believe that the court, and I submit the court has abused its discretion. The custody determination should be reversed. Thank you.
Thank you.
Good morning. My name is Angelo DeMillo. I was the trial attorney for my client, Gene Calvinesso. And I'm avoiding. And I was the attorney for Mr. Calvinesso back in 2014-15. So I had a long history with this case. The court, in my opinion, rightfully made a decision that was based on sound determination.
Long and lengthy decision.
Yeah, 27 pages of the decision. Judge Nathanson's report was 47 pages. A lot of time spent with these parties. What prompted all this, COVID hits. The mother, our position is the mother is a master manipulator, masterful. COVID hits, she doesn't want the son to visit the father during the week. Weekends are okay. Now, if there's COVID, you're protecting stop altogether. So what she does, she stops the weekday access, allows the child to see husband's parents, other people, everybody, but not the father, because she doesn't want the weekday access. So we filed this petition. We instituted the action. We did. We filed a petition to enforce. And then it became this motion to terminate weekday access. Made no sense. What she did then is made all these crazy accusations, baseless. The father's psychotic. He's a drug dealer. He's doing drugs.
Again,
he's violent.
We're aware of all that.
And the judge is in a perfect position to look at the parties. And Judge Noack correctly, I couldn't have said any better. In her examination, the mother has an irresistible impulse to denigrate the father. She cannot help herself. On cross-examination, you ask her a question, she goes off in the left field just to throw in a couple zingers against the father.
Okay, and we understand all that. So I'm gonna ask you to listen
But
to.
there's such a litany here. The case really screams for the fact
What's
that
the change in circumstance? Because that's
her
been the case all along.
continued alienation and influence of this child against the father. It doesn't stop. It doesn't stop.
It's continued. It wasn't an attempt to alienate the child against the father all along.
We were aware of some of it, not all of it. It was only until the mother filed her petition, her motion, when she made these allegations, that blew the lid off everything. And then we thought after the second day of trial, there's more here than just a petition to enforce. she's influenced the child, and the AFC, who was the AFC back in 2014, knew the parties, talked to the counselor. She engages the child in counseling and doesn't tell the father. She changed the pediatrician, doesn't tell the father.
We don't understand all that.
I just get so excited by this because then she says, he's not paying child support. And he was. Anything to denigrate him. It was awful. And I think the judge, up close perspective of the parties and how they were acting and what happened here, and the AFC who was involved back then.
And so
did
you
the
think
same
that's a
thing.
change of circumstances?
Certainly.
It certainly got aggravated.
And Judge Noack then said, okay, we'll keep the time the same so that the father was not denied that
Again, we
weekday.
know that.
But he also granted the 85 days, which is 85 days lost from the time that hit, because we had a calendar, these are the days he lost, which I think was correct to do in that case. So I'd ask you to uphold the court's decision. Thank you very much.
Thank you.
Thank you.
Good morning, Your Honors. May it please the court. Andrew DePasquale. I'm the AFC, not the AFC that was here in 2014. I have substituted as counsel for Mr. Caparella. I'll rest on my papers for both points with the exception of point 2. I just want to make the point that this is essentially a parental alienation case and it wasn't mentioned in appellant's brief. And I thought that was telling.
Did you substitute judgment?
Did I substitute?
Did the AFC substitute judgment for the child?
So I met with my client. I apologize, Judge Reed.
No, I'm just
Oh,
asking.
yeah, so I met with my client last week. He indicated that he likes how the current arrangement is. He likes about a 50-50 split, which I thought was telling that was what the trial level AFC was saying that his client's position was until the email came the day of trial, which, as the court put it, parroted the mother's position. So I don't know if that answered your question. Okay. So, and then just briefly on how the child's doing now. So he is, as appellant indicated, the visitation schedule didn't really change. It's essentially 50-50. That's what it's been. It's just custody that changed.
How old's the child now?
He's 14. And then, so it is this 50-50 split now, except for those makeup days, which I think there's going to be about 33 coming in 2025. He's doing very well in school. So I would just ask that the court affirm the lower court's decision.
And he supports the position that's existing now?
He likes the current arrangement. He wants this to end. You know, he's seeing his parents on about an equal basis. He's very defensive about his mother. He does have a very close relationship with his father as well. He likes the general split. He just wants this case to be over with.
Thank you.
Thank you.
9:55. Angeli Johnson and Sean Johnson versus Reyes Nizam, MD.
Good morning, Your Honors, and may it please the court, Gabrielle Bull on behalf of Dr. Picciano, Dr. Nizam, and their respective medical groups. The lower court should have granted defendant's motion for summary judgment for two fundamental reasons, which are issues with the expert affirmation.
Start with, do you think that this appeal is moot, that it should be dismissed? Because weren't there some
It was an amended complaint, wasn't there?
There was an amended complaint, Your
There
Honors,
was
but the
because of
decision
the-
was rendered after this decision predated the amended complaint.
Right.
And so the amended complaint added a claim for wrongful
Right.
death.
So this decision, then we have now a new amended complaint, correct?
Correct, adding a cause of action for wrongful death, which could have been asserted regardless of whether or not this motion had been granted or denied. So that if this motion had been granted and all of the claims against Dr. Picciano Nizam thrown out, the same wrongful death claim would have been added or simply asserted separately regardless. So no, this decision
Procedurally,
is,
that's how it should have been done, correct?
I'm sorry, Judge, I didn't follow that question.
Then go on.
Okay. So the first issue with the expert affidavit in opposition was that there was no foundation for rendering opinions on a primary care provider's.
If I may, let's go back to the procedural issue here.
Yes,
The
Judge.
plaintiff passed away
Correct,
after the order was entered.
correct.
And so the amended complaint was a response to this in connection with the substitution
Of the estate,
of the
correct?
estate, right?
Yes.
And so we have a new cause of action that was brought about in connection with the substitution, correct?
Correct, a cause for wrongful death, yes.
Right, right.
Yes, which would have been
And you're
asserted
taking-
regardless.
But is your position here now that that new complaint, the amended complaint, didn't raise new claims, new causes of action, a new set of facts that are now before the lower court?
It did for the wrongful death action. So instead of the alternative would have been to simply hold the substitution in abeyance while resolving this appeal, because that, like I said, the decision, if it had granted our motion for summary judgment, then those claims would have been gone. So those
It didn't
claims.
grant you, it denied the motion, defendant's motion for summary judgment.
Correct, Your Honor, but the appeal was pending at the time. And again, those claims would have been out the door had it been granted. So there, the plaintiff wouldn't have been able to reassert those same claims had it been granted. And it's not like the motion was pending at the time that the estate was substituted. The final decision had been, or what would have been potentially a final decision, had already been issued at that time. So therefore, this decision and this appeal isn't moot because those
But
claims.
to be clear, you moved as against the first complaint. We have an amended complaint with a fresh answer.
Correct, yes, Your Honor.
With really a fresh opportunity to move under 3212, right?
That's correct, Your Honor, but this appeal was this appeal was already pending and this decision.
So what happens?
Come down.
Right, right. So the wrongful death, your position here anyway, if we were to reach the merits, the wrongful death, the new cause of action would continue under the amended complaint, correct?
You're correct, Your Honor, it would. But that again would be something that we would then address,
And another
separate-
summary judgment motion.
potentially, Your Honor, that would be a future litigation consideration.
Well, the Lippens versus Winkler case.
Yes.
Indicated there's filing an amended pleading renders moot an appeal from an order denying summary judgment as to an original pleading. How is that different here?
Your Honor, I'm not familiar with that case. However, I do believe there's case law out there regarding what that amendment is and whether it's a new cause of action or if it's additional theories of liability under the same
The
claim.
new cause of action, I think, and additional facts were alleged in the amended complaint.
Correct. Essentially,
it's
the
different.
former plaintiff had passed.
It's new, right?
That wrongful death action is yes, but the medical malpractice claim has remained unchanged. So that decision, the motion papers would all be the exact same regardless of if we simply withdrew and refiled.
Okay, again, but you've added something, so.
The wrongful death claim.
Yes, so we'll have to look at that procedurally very carefully. Okay.
Yes, Your Honor. Just briefly on the issues on appeal themselves, our brief sets forth both the qualifications that were alleged by the lower court to be sufficient. Those qualifications weren't contained or otherwise claimed in the expert affidavit. There was no even attempt at asserting a familiarity with the standard of care that's applicable to primary care physicians, solely to gastroenterologists. And with regard to the second and third issues, unless Your Honors have any questions, I'll otherwise rest on my brief.
Thank you.
Morning, Your Honors. Charles Feltitano on behalf of the respondent.
I think you can pretty much guess what we want you to answer here.
Go ahead.
What about procedurally?
Procedurally, Your Honor, not being familiar with the Winkler case that Judge Montour referenced, the issue is really a damages question. There's no real new allegation as to the facts that occurred up until the time of the diagnosis of cancer. So the complaint is simply an additional component of damages as it relates to that. And those go part and parcel to whether or not there was negligence as to the issue of causation. And so I think, and I'm almost supporting Gabby's position that that the issue at hand before the court won't change should this be moot and we come back. It's going to be the same argument simply because it's a damages issue. It's not going to change whether or not they were negligent, and whether or not that was a cause of the injuries. It's what are the injuries? And subsequent to the motion and subsequent to the decision by the judge, and while the appeal is pending, obviously, and sadly, Miss Angeli Johnson passed away. So I don't know if that answered your question, but that would be the respondent's position. Is it's really just an issue of damages that would then be addressed at trial, depending on the decision by the court, or if there is one, which obviously I think there should be. I think Judge Lemondola was accurate in his decision, getting to the merits of the expert witness affirmation or affidavit. He does lay out that he's trained in internal medicine, qualified, and gives opinions within a reasonable degree of medical certainty within the field of internal medicine and primary care. Judge Lemondola cites the Chills case, which the Fourth Department ruled on in 2017, that basically addresses this issue directly. With regard to the second issue, that issue of speculation, again, our expert outlines very specifically what the complaints were that led to the failures to do certain testing, a referral, no digital rectal exam, no fecal occult, no imaging for about a 4 or 5 year period. And then our oncologist outlines the causation component as to the likelihood of death at the various stages of the years involved. So,
Thank you.
okay. Thank you. Thank you, Your Honor.
9:57. Michelle Furlong and Jeff Furlong versus Shunwai MD.
Good morning, Your Honors. Please, the court, John Collins on behalf of the plaintiffs in this action. And it's my position on plaintiff's behalf that Supreme Court abused or improvidently exercised its discretion in granting Dr. Shenoy's motion to sever plaintiff's first cause of action, which sounds in medical malpractice and was asserted against Dr. Shenoy and basically through vicarious liability, Kaleida Health, from plaintiff's second cause of action, which alleges that Kaleida negligently extended privileges to Dr. Shenoy. Contrary to Dr. Shenoy's argument in the trial court's decision, evidence relating to Dr. Shenoy's prior malpractice and medically established visual spatial deficits does not constitute impermissible proof
Counselor,
of Dr. Shenoy's
let me interrupt
propensity.
you here for a moment. As
Yes.
I understand your first cause of action on the malpractice, it's really two prongs. One, the defendant committed an error during the procedure. But the other error the defendant committed was going into the procedure by continuing to practice.
Yes, Your Honor.
Right. And your position, though, is that the evidence to support the second prong is really the same evidence that you would be offering to support your second cause of action against Kaleida.
Exactly. Your Honor.
And so to keep this straight, Kaleida didn't move to sever. Dr. Shenoy moved to sever. So that evidence is coming in against him either way, correct?
Yes, Your Honor.
Right.
Because our, as Your Honor indicated, our medical malpractice claim encompasses Dr. Shenoy's, professional negligence in continuing to practice interventional radiology when
He knew he didn't have
8 years before this
He
operation.
knew he didn't have the ability to perform this. That's your position. You should be allowed to, you want to have an opportunity to prove that. So, but let me see if I can understand where we are right now then. If we sever the first and the second causes of action, let's assume that you're successful in the first trial and you find, and the jury finds that the doctor committed malpractice during the procedure itself. And then we go to the second trial. Do you have to prove that again when in front of a separate jury?
That's a good question, and I think it might depend on the strength of our proof as to Kaleida's vicarious liability
Set
under
that
a
aside for a
respondeat
minute.
superior.
You say the same thing. Go ahead.
Yes, set that aside for a moment. In the second cause of action, it's the claim is that Kaleida negligently credentialed their physician. But an element of that is that he committed malpractice during the procedure.
Right.
Potentially, we would, if this goes all the way, If you win the first trial and you find the doctor was negligent, then you got to come back in the second trial before a second jury and do it all over again.
Right. So there's going to be, prejudice of the plaintiff, and that would needlessly require second trials addressing both elements of the malpractice claim. That is,
What about the prejudice to the defendant then? Using that information of the prior malpractice Abdullah case, isn't that creating an impermissible propensity then?
I don't think
by the
so.
doctor? I mean,
I don't think so, because the argument is, and the claim at trial will be, not that this is a guy who just commits malpractice, left and right. It's that because of his prior testing in 2014, which revealed these problems, his subsequent operation upon Marianne Issa, which resulted in her death because of his visual spatial problems, that he was professionally negligent in continuing to practice his field, even after those elements, arose in 2014, 8 years before the surgery.
But the only way you can use that is by utilizing that information from that prior incident.
But I think, any potential prejudice that the jury would consider this to be propensity proof can and would be obviated by a charge from the court saying you are not to consider this as proof that this doctor has a propensity to commit malpractice.
Counsel, I'm sorry, but as I understand it, though, it isn't just proving that he did. The proof that the defendant physician wasn't competent doesn't necessarily come from all of that prior bad acts, but from the objective test that shows that he was suffering from the visual incapacity, correct?
Yes.
That's the proof.
Chronologically, that's the proof, but I think, evidence of the malpractice that he committed in 2014 following that testing would likewise be admissible. Again, not to show propensity.
You're only getting to that because that's part of the Collida case then. But as far as the negligent credentialing.
Well, no, I think
based upon those studies that were done in 2014 concerning his visual impaired deficiencies, that relates to the credentialing case. But the only way you're going to get to that is by introducing the Abdullah case.
right, but I think it relates more than to the credentialing. I think it also relates to Dr. Shenoy's, negligence, as I said, in continuing to practice, because not only was there testing, but, that malpractice involving the Issa case put him on notice that indeed there is a visual spatial problem here, because he pierced the, patient's
Understand that.
thymus there. And so it's, I cite, Supreme Court decision Doe versus Sharman, this case, which obviously is not controlling here. But I think it's instructive in that there the court held that because the defendant doctor was aware that he had this mental defect that basically, led him to act inappropriately toward a patient during the course of an exam, that, he was negligent in continuing to practice as he practiced. And there was, proof of, actions taken toward a prior patient. Here, there is proof of actions taken toward a prior patient. Again, submitted not for propensity, but to show essentially notice.
That's right. I think I'm going to say this is a very interesting case, very interesting issue. And we'll look at all those things very carefully.
Yeah, just to conclude, I think that severance is unwarranted and would be more prejudicial than any arguable prejudice to Dr. Shenoy here, because as already indicated, would needlessly require separate trials, thereby wasting judicial resources and
You
obligating
could have two separate verdicts on that.
and giving rise to the potential for inconsistent verdicts after plaintiff was forced to essentially spend money twice on the same experts, call in the same witnesses. And it's really going to be the same issue against both the hospital and against the defendant doctor here.
Thank you.
Good morning, Your Honors, and may it please the court. Jesse Baldwin for Dr. Shenoy and his PLLC. I'd like to start by addressing Justice Del Conte's question about aren't you going to have to prove, isn't the plaintiff going to have to prove malpractice all over again in a second negligent credentialing trial if the plaintiff has already proved malpractice in the separate malpractice trial? And the answer is no, because Kaleida is a defendant in the malpractice case. In the separate, even severed, Kaleida is still a defendant as being vicariously liable to Dr. Shenoy or for Dr. Shenoy's negligence in the malpractice case. So if there is a finding of malpractice against Dr. Shenoy, that finding is binding on Kaleida in a separate case under res judicata. That issue does not have to be addressed in the second trial.
But that may be the case, but the question is on what grounds, right? When an interrogatory is placed before the jury as to where the defect was in the standard of care, it might be the doctor misperformed the actual procedure, or the jury could find that the doctor knew or shouldn't have known not to go into the procedure. So the jury is going to be faced with multiple questions, and we're going to have multiple interrogatories before both of these juries as to what's the finding in terms of where the malpractice may be. We're correct?
I respectfully disagree, but I do think it's an issue for a separate day, and I'd love to explain because I understand Your Honor's question.
Right, but you do agree that in the second trial, if there is the second trial in credentialing, that the element that the plaintiff would have to prove that the doctor committed malpractice in performing the procedure.
No, I don't. They don't have to prove that in the second trial because it's already going to be addressed one way or another in the first trial. If no malpractice is found in the malpractice trial, there will be no second trial. If malpractice is found in the first trial, they don't have to prove that element in the second trial against Kaleida because of res judicata, because Kaleida is a defendant in the first trial. There would be limited issues. Now, I do want to address.
I'm sorry. I should let you finish.
No, it's okay.
Answering that.
Of course, I want to answer your own.
But where I'm struggling with this is Kaleida didn't make this motion. It's the physician doctor who's saying that it's prejudicial, that all of the evidence is coming in the first trial. Anyway, that relates to his the plaintiff alleges that the doctor was incapable of performing this procedure reasonably due to his visual deficiency. That's coming in.
Respectfully, Judge, I said, as I said before, I disagree that that's coming in, but that is an issue that doesn't have to be addressed, and I can explain both of my positions on that. The first being, it doesn't have to be addressed because the plaintiffs have also made clear here today, in argument to you, as well as in their papers, as well as right in their pleading, that they intend to prove in the negligent credentialing case, not just the testing, but also past acts of malpractice, which falls squarely in Mazzella v. Beals, the Court of Appeals decision. That cannot be included as evidence against a physician in a malpractice case. Past evidence of malpractice with a different patient, different time, unrelated, cannot be admitted. And they intend to use that in their case. So by ordering, and I will get to the second point as to why I think that's an issue for another day, but by ordering severance in this case, the trial court solved multiple problems. It said the plaintiffs can preserve, it preserves both claims. You can have both claims. You can use the evidence in the negligent credentialing claim that we would have to preclude you from using if the malpractice claim was with it. We're going to let you have that by letting you have the two claims. It also protects.
I'm sorry, that sounds like you're saying the plaintiff gets a benefit from this. The plaintiff gets to chart his or her course here in terms of how they want to present their cases. What they've said is we want one jury deciding these issues that are so intertwined. And because really it sounds like this is more like a motion in limine. We're looking ahead at what the trial evidence is going to be is in terms of focusing in on what is the effect of causing this plaintiff to go into two separate trials to prove what appear to be very similar factual issues.
As well as looking at how it implicates the substantial rights of the defendant, which is respectfully judged the test that this court has held, the test that the Court of Appeals holds for interpreting 603, which is a substantial right of the defendant. Is it implicated? And if it is, then severance is appropriate if it solves that problem, as it does here. Mazzella v. Beals, the Court of Appeals specifically said in 2016 that evidence of prior malpractice being admitted in a case of malpractice against the same physician implicates a substantial right. Use those words, the exact words that this court held in 2010 in Nelson is the test for severance. That's in our brief. In addition, I would say, I'll get back to what I mentioned to Your Honor as a test for another day, is because it doesn't matter whether the plaintiff is going to be allowed to present that claim of you shouldn't have gone in at all, you shouldn't have continued to practice, it's malpractice to continue to practice. That's a question for another day, because they're also planning to present evidence of past malpractice, which is prohibited.
Right, but I'm sorry, Counsel, but that's the issue in front of the court anyway in the first trial. The court still has to sort out what evidence is going to be admitted. And you may be right that a lot of evidence the plaintiff wants to bring will be excluded.
But it wouldn't be in their negligent credentialing case. So it protects their rights that way. And then I do want to say why, even though it is a question for another day, that claim, which they raised for the first time in opposition to the motion, is an unpled claim. The claim that it is negligent to continue practicing after this past malpractice and after the testing. The only precedent for such a claim, the plaintiff is able to cite exactly 0 cases where such a claim was ever challenged, with the exception of Doe v. Sharma, a Supreme Court case in Nassau County, which does not involve a severance motion, does not involve a propensity evidence objection.
But the case.
Okay. I would just like to point out as well that case has a nuance to it that court says shouldn't have precedential effect because it's the specific circumstances of this case, which involves stipulations. In that case, the parties stipulated away the issues that would implicate this prejudice of a propensity evidence. Those issues were not an issue in that case because they were stipulated away. They stipulated that the act took place, that it was an assault, and that it was involuntary. So unlike in this case, where the issue of whether or not Dr. Shenoy carried out procedure on Mrs. Furlong consistent with the standard of care, that issue cannot be heard by a jury that hears evidence of Dr. Shenoy's past malpractice. That problem is solved while protecting the plaintiff's interests in presenting such evidence as against Kaleida by the severance.
Okay, I think you've made that very clear.
Okay.
Anything further?
I do, Your Honor, and I recognize the signal that you guys understand, but I want to say one other thing. Reversing this severance on the basis that the plaintiff wants to prove that you can bring in past malpractice as long as you allege it's malpractice to continue practicing opens a Pandora's box. Every lawyer representing a plaintiff in a malpractice case who has any substantial basis or reasonable basis to allege past malpractice will then allege past malpractice in every malpractice case. It will
As long as they read our decision.
They will. I'm familiar with the malpractice bar in Buffalo. They will. They're all excellent lawyers. And then it will, of course, open a box on discovery issues that will all be before this court of where do you draw the line for discovery of potential malpractice alleged regarding past patients who are not parties. The Court of Appeals in the Weiner case, which I cited before, Your Honors, or in our papers, our brief.
But Counselor, isn't that the same thing if severance is appropriate, that every time there's a credentialing claim, they have to be severed? Isn't because it goes back and looks, I mean, the reason why the credentialing claim exists is that the credentialer is aware of things that had happened in the past, including other malpractice.
Well,
so
two things, Justice Delgado. One is only if it's past evidence of malpractice they intend to use, and two, only if the physician raises it. And that's why Kaleida didn't raise this. It's not Kaleida that's prejudiced by it. It's us. It's Dr. Shenoy. And in other cases, the only other cases that have been cited here where that have not been severed is because substantial prejudice is not found. Okay, a substantial right is not found, and there are cases where these claims were allowed to proceed jointly, where it was never objected to by the physician defendant. So yeah, they can proceed jointly if the physician defendant doesn't object to. There may be strategic reasons to do that. We considered them.
We'll look at that very carefully. This is
Thank you, Your
fascinating.
Honors.
Thank you.
The court will stand in recess, CAVA.